Imagine being in a prison for years without a court ever saying that you are guilty. Not because a trial has ended, but because the law makes it extremely difficult for you to even step out on bail. This is the reality for many people booked under India's anti-terror law, that is the UAPA. Umar Khalid's case is one such example. At its core, this is not just a story about one individual, it is about how the bail law works, or often doesn't work under the special law, and whether the criminal process itself has started to feel like a punishment. Let's understand this issue. Who exactly is Umar Khalid? Umar Khalid was arrested in 2020 in connection with the Delhi riots case. The prosecution alleges that he was part of a larger conspiracy that eventually led to violence. Importantly, as per the defense, there is no allegation that he directly committed any violent act. Yet, he has remained in jail for years without the trial being started. This brings us to the larger issue in the criminal law. Bail exists to protect personal liberty. It ensures that a person is not punished before guilt is proven. Umar Khalid's continued incarceration forces us to ask whether that principle still holds true under the UAPA law. To put this into a perspective, official data shows that over 10,000 people were arrested under the UAPA in India between 2019 and 2023, but only about 335 were convicted in that entire period, according to the figures officially tabled in the parliament based on the NCRB record. In 2023 alone, nearly 2,900 people were arrested under the act, yet the conviction rate stayed very low. These numbers show that people are often booked under the serious charges long before any legal determination of the guilt is made. Let's understand how the bail normally works versus the bail under the UAPA. Under the ordinary criminal law, the courts follow a simple rule. Bail is the rule and jail is the exception. An accused person is presumed innocent, and detention before the conviction is meant to be temporary and in rare. However, the UAPA changes this balance completely. Section 43D subclause 5 of the Act says that the bail cannot be granted if the court believes that the accusations against the accused are prima facie true. This one provision shifts the focus from the liberty and places national security at the center of the bail decision. Therefore, these legal provisions play out against a backdrop where the majority of the UAPA trials remain pending for years, with thousands of cases taking long to reach even the trial completion. Let's understand the judicial interpretation on this point. In 2019, the Honorable Supreme Court of India, in the matter of National Investigative Agency versus Zahoor, Ahmad, Shah, Watali, explained how courts should apply Section 43D(5). The court held that at the bail stage, judges must accept the prosecution's case as it is. The defense arguments cannot be closely examined. Evidence cannot be tested for credibility, and the contradictions cannot be explored. Keeping it very simple, in simpler terms, if the charge sheet appears believable on paper, bail must be denied. This judgment became the foundation of the UAPA bail jurisprudence and has shaped outcomes in most cases ever since. Let's apply this law in the Umar Khalid's case. When courts examined the Umar Khalid's bail application, they applied this Watali standard very strictly. They looked at the charge sheet, accepted the prosecution's narrative at the face value, and concluded that the accusations were prima facie true. Questions about the intent, proportionality, the delay in the trial, or the lack of the direct violence were pushed aside. Legally speaking, once Section 43D(5) is triggered, the court's ability to grant the bail becomes extremely limited. Let's compare this case with the other UAPA cases. A pattern emerges wherein the Umar Khalid's case is not an exception. In the Bhima Koregaon case, several accused persons spent 5 to 6 years in jail while their trials barely moved forward. Bail was repeatedly denied using the same reasoning: seriousness of allegations and the Watali standard. Similarly, in the case of Father Stan Swami, bail was denied despite age and several health issues. He ultimately died in custody. These cases show a clear pattern. Once UAPA is applied, bail becomes nearly impossible, regardless of individual circumstance. But there are few exceptions wherein the courts have granted bail as well. The rare exceptions have been such as Union of India versus K.A. Najib. In that case, the Supreme Court granted bail not because the charges were weak, but because the accused had spent several years in jail and the trial was nowhere close to finishing. However, such decisions are only treated as exceptions. They depend on extreme delay or humanitarian ground, not as a general recognition on the right to liberty. This brings us to the central legal conflict. On one side is Article 21 of the Constitution, which guarantees personal liberty and presumes innocence. On the other side is the statutory framework that prioritizes national security and restricts judicial scrutiny at the bail stage. Both are really important. The result is a paradox. A person may be legally innocent yet treated as too dangerous to be released. Bail under UAPA becomes a matter of discretion sometimes and not only the rights. The consequences because of this are such that the larger prison reality in India also shows that the gravity of this problem. Nearly 74% of all inmates are under trial, detained before conviction, often for years. The consequences of this system is serious. Trials under the UAPA takes years. Bail is routinely denied and pre-trial detention becomes long and uncertain. So what happens is that in such situations, the criminal process itself begins to resemble as a punishment. Even if an accused is eventually acquitted, the years lost in prison can never be returned. Now, what needs rethinking Umar Khalid's case, when seen alongside with other UAPA cases, forces us to think about the bail jurisprudence in India. National security is undoubtedly important, and therefore right now Umar Khalid is behind the bars. But it cannot come at the cost of completely eroding the personal liberty. Real reform lies not in weakening the security laws, but in restoring balance, wherein allowing the courts to meaningfully examine evidence, consider delay, and protect liberty even under special statutes. That is very important, because a legal system that punishes before proving guilt risks losing its constitutional soul. Therefore, even though in the matter of the Umar Khalid, wherein the trial is pending and he has been given one more year to apply for the bail, based on the circumstances as of now, it can be clearly seen that yes, it is correct to put him under the bar. But let's take it from the example of a personal rights that is enshrined under the Constitution. Whether he should have been granted the bail or not, that Supreme Court has to decide. But the bail jurisprudence is for us to discuss. I hope you like the analysis of this bail jurisprudence, and if you like such content, please don't forget to like, share and subscribe. Say Something Simarjeet. See you in the next video.